Namaskar. Can I start, Anjana ji? Good afternoon to all. Namaskar. Uh, uh, my coordinators of the all the coordinators under the regional center, Noida, uh, Director Regional Services Division, Dr. Rumi Ahmed, Dr. Dr. O.P. Sharma, Director NCIDE, and our colleagues sitting in the regional center. I welcome to Rumi Upadhyay, Rumi Ahmed regarding, and she will deliver a lecture on copyright issues in the legal writing. We also welcome to all the coordinators, my colleagues sitting at the regional center, Dr. Kiran Mukherjee, Additional Director, Anjana, Assistant Regional Director, Dr. M.A. Laskar, Deputy Director, Dr. Rumi Ahmed. She is a legal expert and she will deliver the lecture on the copyright issues in the legal writing. Today, as you know, today is the World Intellectual Property Day. Under the Innovation Club of the IGNOU Regional Centre, Noida, we are celebrating days. We are inviting the experts on the different topics. Today, we have invited Rumi Ahmed ji to deliver a lecture. Now, I request Dr. Anjana ji to start the Kulgeet.
ये जन जन का विश्वविद्यालय ये जन जन का विश्वविद्यालय सरल सुगम शिक्षा का आलय जन जन का विश्वविद्यालय जन जन का विश्वविद्यालय ज्योत जलाए ज्ञान की स्वाध्याय की अनुसंधान की राह दिखाए वंचितों को शिक्षा के अधिकार की न उम्र का कोई बंधन न बंदिश परिधि घर घर है बना शिक्षा का देवालय ये जन जन का विश्वविद्यालय जन जन का विश्वविद्यालय जन जन का मान है सम्मान है पहचान है जन जन का मान सम्मान पहचान है राष्ट्र का मान है अभिमान है अभिमान है राष्ट्र का मान वरदान अभिमान है सर्व सुलभ सर्वोत्तम शिक्षा का है नारा मुक्त और दूरस्थ शिक्षा का महालय ये जन जन का विश्वविद्यालय जन जन का विश्वविद्यालय देश विदेश पटल पर भूषित नवाचार से सज्जित गुणवत्ता से परिपूरित ज्ञान वाणी ज्ञान दर्शन ज्ञान कोश से संचित ज्ञान कोश से संचित सर्वगुण संपन्न शिक्षा का हिमालय शिक्षा का हिमालय यह जन जन का विश्वविद्यालय 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 जन जन का विश्वविद्यालय
Thank you, Dr. Anjana. Now I request Dr. Shiran Mukherjee, Additional Director, to introduce our legal expert, Dr. Rumi Ahmed.
Good afternoon, everyone. Our Regional Director, Dr. Amit Chaturvedi. uh, my colleagues, Dr. Lashkar, Dr. Anjana, our senior coordinators of the various study centers under RC Noida, and my other colleagues of the regional center, as well as the students who have enrolled today in this online webinar. Uh, this online webinar, which has been titled as Copyright Issues in Legal Writing, this is a lecture which is going to be delivered by our law expert, Dr. Rumi Ahmed. Well, I would like to tell all those members who are present today in this webinar that this webinar is being conducted under the auspices of the Innovation Club of Regional Center Noida, which is a part of the University Innovation Center, that part of NCIDE. And we are celebrating this day with this lecture. And this day, as I would like to tell all of you, if in case some of you have logged in at a later stage, today we are celebrating the World Intellectual Property Right Day. Well, as you all know, friends, we have amidst us the law expert, Dr. Rumi Ahmed, who has an experience of more than a decade in teaching, training, and research in legal subjects. She is a doctorate in law. She has taught a number of law courses in Guwahati University, GGS Indraprastha University, and the Assam Royal Global University. She has also the credit of having authored a book on rights of persons with disabilities in India, and she is also credited with a number of research articles in reputed journals, national and international both. She has presented a number of papers in national and international seminars and conferences, and she is also the resource person in various programs which are being organized by the government, state government, national legal bodies, and also non-government organizations on various occasions. Dr. Rumi Ahmed is also a consultant in multiple action research group. She has worked as assistant project coordinator in disability law unit of Shishu Sarohi, a center of rehabilitation and training for multiple disabilities. She is also part of our IGNOU Academic Counselors fraternity. I hereby welcome Dr. Rumi Ahmed and request her to deliver this lecture on copyright issues in legal writing. Dr. Rumi Ahmed, please.
Before calling Rumi Ahmed ji, I would like to invite Dr. Om Prakash Sharma ji, Director, National Centre for Innovation and Distance Education, IGNOU. I request Sharma ji, please give the remarks and give the address about the World Intellectual Property Day today we are celebrating. Sir, please.
Thank you very much, Chaturvedi ji. I think my video is not visible, no? Yes, some problem is there.
Problem, sir.
Okay. Indeed, it is my pleasure to be part of this today's program, World Intellectual Property Right Day. And because IGNOU is very much promoting and supporting our students towards innovation in startup. In that context, the knowledge, awareness about this intellectual property, patenting, these all things is very important. So that's why today's days and inviting expert, sharing, learning her about the issues related to IPR and patents, and knowing about the experience from her, then I think it will be good for all the students and the academic facilitators, academic counselors of the study centers. Uh, we have seen while working with the students that many of the students, IGNOU students, are doing very brilliant work. They have very brilliant ideas. They are doing innovations also. They are taking up some initiatives to set up their startups and enterprises. But they are very, very much that you can say in lack of knowledge about the IPR issues. They don't know even at what stage they should reveal the idea, to whom this idea should be told and to whom it should not be told, at what stage it should be told, what are the procedures, steps to protect its that intellectual property right. So many issues are there. I think in that context, this kind of sessions, especially focusing on the IPR issues, and that too on the World Intellectual Property Day, will be very useful. So I would like to thank the Regional Center Noida, especially Dr. Amit Chaturvedi ji and his team, to organize this program under the Innovation Club at Noida. And you know, this Innovation Club is a very important entity at the Regional Center, not only to create awareness, but also to encourage and motivate students towards innovation, startups, and also to take care of their intellectual property. So, with that, thank you very much for giving me this opportunity to say my words. I am really keen to know more about the intellectual property issues, because this is a very new topic to all of us. And whenever we listen to expert, we always learn something new, and that we try to share with our students also. And so, without taking much time, I think Chaturvedi ji, we should listen to our expert. So, thank you very much.
Thank you, Dr. O.P. Sharma. Under your dynamic leadership, we have created the Innovation Club at the Regional Center Noida. And we are conducting the series of lectures, and we are inviting the experts from the different fields. Today we have invited Dr. Rumi Ahmed, and she's a legal expert, and she will deliver the lecture on the copyright issues in the legal writing. Now I request Dr. Rumi Ahmed, please deliver your lecture.
Okay, am I audible? Hello, am I
Yes,
audible?
yes, you go ahead, please.
Yes. Namaskar and a very good afternoon to all present on this occasion of World Intellectual Property Rights Day. Today is 26th of April, and every year this day has been celebrated as World Intellectual Property Rights Day. So, respected Honorable Professor Nageshwar Rao, Honorable Vice Chancellor Sir, Dr. Shrikant Mohapatra, Pro Vice Chancellor of IGNOU, Dr. Umesh Chandra Pandey, Director IGNOU, Dr. Om Prakash Sharma, Director IGNOU, and Dr. Amit Chaturvedi Sir, and all the directors, senior directors, IGNOU officials present in this today's occasion, my dear learner students present here. And I foremost, in the very beginning, I would like to congratulate IGNOU Regional Centre Noida, and specifically this Innovation Club for organizing this type of lectures and creating this kind of platform where we can discuss and we can exchange our thought, our knowledge with among ourselves and with our learner students. So, as we know that today's topic, categorically, as a law expert, I have chosen that copyright issues in legal writing. So copyright issues, we heard what is copyright, and many a time, and in academic journey of all of us, most of us have written articles, research papers, our PhD thesis, and books also. And most of the time we have written that C kind of mark, right? Copyright. That is the mark of copyright. That so today I'll try to deliver, try to exchange my knowledge, my little bit expertise in the field of copyright law. So today I'll discuss a few: what is copyright law, what is the subject matter of the copyright law, who can file a copyright application, how it can be filed, right? And what are the provisions there in the copyright laws, which is very much prevalent in India. So first of all, let me discuss that what is the objective of copyright law. That is why we need a law, or why we need a subject to know about, that is copyright. What is the importance of copyright law? So this is nothing but to guarantee, right? It gives some kind of guarantee to the original expression of writers. And when we say writers, that we all here are uh, writers. We all here are writers. And this copyright law is not only limited to writers, but there are certain other persons, certain other individuals also. And these writers may also be a songwriter, it may be a designer, it may be an artist, and other creatives. So all those who are related to some kind of creativity, as well as film and sound recording producers who actually invested, who actually risked their money to present their works to the public domain. So no, copyright is something that one has to firstly understand that originality must be there, and second most important thing is that some kind of creativity must be there. So our works, knowledge, and suggestions can be freely expanded upon by others. Now, interestingly, here there is a judgment that is given by Madras High Court in Sulamangalam R. Jayalakshmi versus Meta Musicals, and this is in Chennai in the year 2000, beautifully remarked, beautifully observed that what is copyright actually. So copyright law is to preserve the fruits of a man's effort, labor, talent, or test from annexation by other persons. So this is beautifully given by Madras High Court in the year 2000. Now let me check that what are the that before this law, that Copyright Act in the year 1957, we had this Copyright Act. Now before 1957 also, we had certain other laws which are related to copyright in India. So before 97, there was this international convention, and most important convention related to copyright is the Berne Convention in the year 1886. Now this, as India is also a signatory of this Berne Convention, so India is bound to make law in compliance with this international convention. And that's how this Copyright Act 1957 Act came into force. Now this act after 1957 has many times it has been amended, and in fact it has been amended 5 times since 1958. Because it came into force in the year 1958, but the Copyright Act is known as Copyright Act 1957. Now it has been amended 5 times, and the recent amendment, latest amendment, is the Copyright Amendment Act 2012. Now this 2012 amendment was keeping in mind the copyright protection in the digital environment. Nowadays we are digitally advanced, we are technologically advanced in our lives. So this amendment came. What is copyright? So copyright is an incorporeal or intangible right or property. So all the intellectual property rights, actually we call them as incorporeal or intangible property right. So they are not a physical property, they are something which are related to intellectual or intellect. So all other intellectual property rights, there are various other areas. Say for example the patent, right? Patent laws. Also there is the trademark is there. So if you say that literally construed as the right to copy, right? So copyright can be, if it is literally construed, it is the right to copy which presupposes a medium. And the premise that the legitimate owner developed or created the work justifies the property. So this is also an exclusive right which is given by law for a period of time. Why I say this is period of time? Because the act suggests that copyright is a person's life plus 60 years plus other 60 years. So that's why this is say that this is a period of time. That's a limited for a period of time. And in contrast to physical property, uh, the physical property which endures for the lifetime of the thing on which it is bestowed, copyright only exists for a finite amount of time. So the act in its provision, it suggests that it's a person's lifetime plus 60 years. And after this period, the question may arise that after this period, what will happen? If after this time period passed, what will happen of my copyrighted property? That may be a song, that may be a literary work, that may be a film, right? That may be art, anything which which the act covers, which the subject matter of copyright covers, and which itself mentioned in the act. So after this time period has passed, the work enters into the public domain. Now the next question may come into our mind, that who can claim copyright, or what are the other things, what are the other formalities which need to be done to file a copyright, or question may come that is it mandatory that if I publish a book I need to file a copyright? If I publish an article, or if I draw something that need to be copyrighted, is it mandatory? If I do not do that, what will be the consequence? So who can claim copyright? Yes, authors of any literary work, then any composers, artists, or their assignees. They can claim copyright for their original works to print, that to publish, and sell copies of original work. This is one thing. Then secondly, second most important thing is that compared to all other copyright, say for example patent or trademark, for copyright, the filing copyright, it's the easiest form of IP, intellectual property, that one can easily create and own. Because the formality is very simple. I'll go to the formality very soon, but just one has to put that symbol C within that circle. And even a minor can apply for copyright also. Now, of several sections of coming to this Copyright Act, into briefly, what are the provisions mentioned under the Copyright Act 1957? Like all other legislations, the first section, few sections, specifically section 2, is related to the various important definitions of the act. And for any legislation, to understand any legislation, or to like apply those provisions, right, one has to know at least few important definitions under this Copyright Act. I will not go into discuss all the definitions, but yes, there is a definition, very important definition here, that is artistic work. What is artistic work mean? So a painting, a sculpture, a drawing, including a diagram, map, chart, or plan, an engraving or a photograph, whether or not any such work possesses artistic quality. So this is, if any person, if any person want to file a copyright for an artistic work of those, these things must present. Secondly, what is artistic work? Artistic work means, this is an inclusive definition. The artistic work means, number two, a work of architecture, architecture, and any other work of artistic craftsmanship. So this is mentioned under section 2. Let's see how the word author has been defined under the Act. In relation to a literary or dramatic work, the author of the work. In relation to a musical work, the composer will be considered as the uh, author of the work. In relation to an artistic work other than a photograph, the artist will be considered as the author of the work. In relation to a photograph, the person taking the photograph, I'll discuss a case, very interesting case regarding this. In relation to an artistic work other than a photograph, the artist. In relation to a photograph, the person taking the photograph. In relation to a cinematograph, film or sound recording, the producer will be considered as the author. And in relation to any literary, dramatic, musical or artistic work which is computer generated, the person who causes the work to be created. So this is the definition of artistic work and author. There are other definitions also mentioned under the Act: cinematograph, film, composer, dramatic work, engravings. Then literary work. So literary work includes computer programs, tables and compilations, including computer database. Musical work means a work consisting of music and includes any graphical notation of such work, but does not include any words or any action intended to be sung, spoken, or performed with the music. So these are the certain definitions under the Act. Now, uh, with this act, the copyright rules has also been notified by the Ministry of Human Resources and Development once in the year 2013, and later on it has been recently changed in the year 2021. So now we have to abide by the rules of 2021, copyright rules 2021, as well as the all the provisions mentioned there in the Copyright Act 1957. Yes. Now, so authorship and ownership in copyright, which is mentioned under Section 17 of the Act, which recognizes the author as the first owner. So we already discussed that who is an author, right? So author will be considered as the first owner, which states that subject to the provision of this Act, the author of a work shall be the first owner of the copyright therein. And in the case of literary or dramatic composition, the author. In case of musical work, the musician will have the authorship or ownership of the copyright. In the case of creative work, apart from photography, the artist will have the authorship and ownership in copyright. If it is a photograph or photographic work, of course, the artist will be considered as the author, or the authorship will be given to the artist. In case of cinematographic or recording work, the producer will be given the authorship. In case of any work generated by any computer virus, the one who created the same. Now, what are those subject matter? So we now got some kind of hints that what could be the subject matter of copyright. So as mentioned under Section 13 of the Copyright Act 1957, all the subject matters protected by copyright, those are termed as works. So according to Section 13 of the Copyright Act 1957, there are certain works. There are 6 six categories of works uh, which will be considered as the subject matter of copyright. So we can say that for this for these six works, one can file a copyright. So first of all, literary work, and of course, that must be a original literary work. Secondly, the original dramatic work. Thirdly, the original musical work. Fourthly, the original artistic work, the then cinematography films, and lastly, the sound recordings. So, for this, one can file copyright because uh, these are the subjects, these are the things we can understand that some kind of creativity one can relate. Now, there are things, there are certain things which this Copyright Act uh, does not, this act cannot cover these things, certain things. And the Copyright Act, which cannot cover certain things. For example, the any kind of titles, any kind of names, or any kind of slogans and symbols, or any kind of process. Just now, sir has mentioned that IGNOU students they innovate, that innovations, and for innovation, certain procedures and certain processes are required, and these things are not covered by the Copyright Act. Now the question is, if these things do not covered by the Copyright Act, then is there any other law which cover this kind of things? For example, the title, for example, the any kind of symbol, slogans, or any kind of procedures, methods, systems, or procedures. Yes, of course, intellectual property rights, the bigger area, IPR, the other areas, uh, there are other provisions in our law which can cover, which can protect this kind of intellectual property rights. Now, that's this for example, that ideas or procedures, methods, systems, and processes are though not covered by the Copyright Act, but they can be protected under the patent law, filing patent. uh, so patent is something which can protect all those methods and processes and procedures. So, and for this, the laws of patent, this need more formalities are required as compared to the Copyright Act. Similarly, titles. Many a times we had cases where the producers, right, they file cases under copyright law that their titles of the movies are same. He produced a movie of a particular title, and later on some other producer, he produced another film of the same title. Now here the court many time court ruled that titles cannot be protected under the Copyright Act. Now, then is there any other law which can protect the titles? Yes, the titles, the names, the slogans, and symbols, though cannot be protected by the copyright law in India, Copyright Act, but can be protected under the trademark. So we have laws, we have appropriate laws to protect each and every intellectual property right of us. The thing is, there are various formalities are there, which one has to go pass through, and there are different bodies, right? There are different offices which need to be approached. uh, so as I already as I mentioned that patent, so let's see what is the difference between the copyright and patent. Yes, as we can easily connect that a patent protects an inventor's invention, but uh, a patent protects one's product, or if there is some kind of machines. But copyright protects an artistic piece of work. It may be a book, it may be a play, it may be a movie, it may be a song, photograph, or computer software code. Now, for example, we can say, for example, if a and the patent related activities, these are the engineering students. They are mostly uh, deals with this patent related things, because they are the persons who actually involved in developing machines and processes. So if an engineering student developed a machine, say for example, which purifies water, that will be considered as a subject matter of patent, and accordingly the student can file for patent by following the appropriate procedure. But in contrast, the main purpose of a copyright is to protect the expression of unique ideas. It's very important that one's ideas need to be unique. That cannot be a copied one. Uh, Now, as we are mostly discussing that and copyright issues, and copyright is something which is like first copyright, we can connect, we can relate with our literary work or our research work or our articles, books, etc. And many a time we confuse, or we like interchangeably use the term copyright and plagiarism. So we need to check that is copyright same as plagiarism. Copyright infringement is unauthorized use of protected material, whereas plagiarism is using someone else's work or ideas without proper credit, presenting it as one's own original work. Now, copyright infringement is a legal violation. Why I say it's a legal violation? Because we have laws. We have a Copyright Act. So any kind of violation which are mentioned there in the act, right? If this there is an infringement of copyright, so there are provisions mentioned, right? There are remedies mentioned, right? So copyright infringement is a legal issue, it's a legal violation, while plagiarism is uh, not actually a criminal offense. So in no plagiarism for plagiarism issue, UGC has a time to time formulate guidelines, and we hardly hear any cases, any instances where where a person who publish a plagiarized article or write up, that person has been punished, or some kind of uh, criminal case has been filed against him or her. The copyright infringement deals with the unauthorized use of creative works. And again, I'd like to say that this type of creative work can be literature, music, and art, while plagiarism deals with the unauthorized use of someone's thoughts, ideas, and writing. Copyright infringement can result in monetary damages and legal penalties, while plagiarism can result in loss of credibility, academic penalties, and damage of reputation. So, copyright infringement can result in monetary damages. So, already that if someone is like monetary uh, damage happened to someone, that he is facing loss due to, as because his work has been copied by someone, and sell uh, that has been sold by someone in market, and that second person has been earning profit, and due to this activity of the second person, the first person is facing loss. So copyright infringement can result in monetary damages, and of course the legal penalties will be there. Uh, Copyright infringement can be remedied through cease and desist letters or court orders. Plagiarism can be remedied through proper citation or rewriting the offending material. Uh, there are various interesting cases on copyright. In among those cases, in one of the case, very a landmark case, which has been decided in the year 1978. This case is R.G. Anand versus Deluxe Films and others. What happened? The issue in this case was that whether the plaintiff's copyright, there's a particular play, in the play, Hum Hindustani was violated by the defendant's distribution, production, and screening of the movie New Delhi. So, two movies, one is Hum Hindustani and another is New Delhi. And the issue was that whether this plaintiff has copyright in the play of Hum Hindustani and whether this second person violated the defendant's distribution, production, and screening of the movie New Delhi. So same this thing. The issue was, now in this case, the Delhi High Court held that there may be some similarities between two movies, but according to the court, a regular person would not consider the play and the movie to be a duplicate of the play if they were to view both. Right? So originality. This is something how the our judiciary from time to time has decided that how to find out that which is original and whether the any kind of duplicacy is there or not. And this is a subjective matter. So from Supreme Court and various High Court cases, one can understand that how it has been decided and on what basis the originality or the duplicacy need to be decided. Another second interesting case is Tips Industries Limited versus Wink Limited and another, which has been decided in the year 2019. Now here, in this case, the Indian music label, that is Tips Industries, who had filed this case, has the copyright to a sizable music archive, and in 2016, it allowed the Wink Music Limited, which is the defendant in the case, permission to access this archive. Now, both the parties, they attempted to renegotiate the licensing terms at the license's expiration, but were unsuccessful. And hence, the Wink Music Limited, they sought protection under Section 31D of the Copyright Act. This plaintiff, Tips Industries, they contested Wink's use of Section 31D and filed a lawsuit against Wink under Section 14 and for violating their exclusive sound recording rights. Now, issue in this case was whether the Copyright Act has a legislative licensing scheme for streaming platforms or not. In this case, the Bombay High Court, after hearing both the parties, they concluded that Wink had engaged in direct violation on two counts. What they had violated? Firstly, by making the copyright work available under Section 14, which allowed users to download and subscribe to the plaintiff's work offline. And secondly, by making the plaintiff's work available to users via their streamlining platform. And the court determined that the plaintiff was eligible for an interim injunction. That means they had stopped since they had presented strong case and would incur severe financial damage. Another case in the year 2019, very landmark case, Sanjeev Pillai versus Benu Kunnapalli. Issue was that whether Section 57 of the Copyright Act grant the creator of a work particular rights to assert authorship of that work even after assignment of that work. So the court held that no changes can be made in the work of the original author without his permission. So even he assign his work to others, that doesn't mean that he can change his work. So originality must be there. Very interesting case we all heard in the year 2017 and 18, and it went viral. A smiling monkey, right? A very viral photograph of a monkey, and this is known as the monkey selfie case. Actually, the case was between Naruto and David, and this was a case. In US, and from that time, the in India also, the all the legal fraternity was bound to start thinking that yes, this type of issues may come, then what would be the consequence. So what was the case in this case? There was a photographer, the wildlife photographer, US based photographer. Once he went to click a photograph of monkey, but he, due to some reason, he left his camera with all its settings. And what happened? The monkey clicked the photograph. The monkey clicked the photograph, and it was like very beautiful photograph, the smiling monkey, and it went viral, very popular. The photographer name was David Slatter. He filed a copyright claim. Now, what happened in this case? After so many years, the court decided that the photograph, um, when we read the definition of author, it says that in relation to a photograph, the person taking the photograph, it mentioned the person taking the photograph. I'm talking about the act in Indian, but similarly, the US also, the law is almost the same. So we are not talking about non-human here. So as non-human are not entitled to copyright protection, so so the photographer, that is David Slater, and the wildlife sanctuary, in an out of court settlement, they settled their issue out of court in the year 2017, and came to a conclusion, and they came to an agreement that Mr. Slater, that means the photographer, he will donate 25% of his earning, that's the earning from that photograph, for the betterment of wildlife. So this is a very interesting case on monkey. This is monkey selfie case. Then yes, coming to the legal writing, copyright issues and legal writing, how legal writing is different. How legal writing is there any difference between any other academic writing and legal writing? So, research is common in all academic programs, and in legal research and in law profession, research is something which is very much important, whatever profession a law student uh, chooses. So it may be a advocacy, it may be a judge, it may be any lawmaker, right? Any legislative body, it may be academician. Research is part and parcel. So without research, uh, law profession, a person cannot excel in any kind of law profession. So legal research basically deals with the principles of law, and it also deals with legal institutions. So, based upon various legal institutions, and based upon different legal institutions prevalent in different other countries, the research outcome may vary. So, legal research or legal writing, it's a process of identifying and retrieving information which are necessary to support any legal decision making. So, the research findings are published in the form of reports, uh, maybe for various purpose, including personal, business, and academic. So, many a times we have heard that report published on death penalty, a report published on domestic violence. So, these are the outcomes, these are the reports. And Sometime it may be, the report may be like the research, if any case file, any matter comes in front of the court, and the lawyers or advocates, they have to make research. It is what need to be present, what are the principles of law, and how to present this case. So what are the cases decided earlier, and all this. So coming to the academic research or academic writing, and that also in legal profession, research writing, it's a very important part. So research writing, it may be any kind of assignment, it may be any kind of research paper, project, dissertation, thesis, and at last book. Then writing of textbook and reference books, yes, this is also. Then many a time we review a book. So review of a book also comes under the legal writing, that's specifically under the academic writing. And judgment writing by the judges, judgment writing. Then interpretation of decided cases in barrettes. So when we see the different types of barrettes, so cases are decided and various provisions are also interpreted in those barrettes. So these are something different when which legal writing deals with in compared to any other academic writing. Now this legal writing issue, there's another very interesting case uh, which all of us heard, because this is not that the copyright issue dealt with, because the issue, because the that photocopy services, that is Rameshwari photocopy services, which is there in the Delhi University. So it is very famous photocopy services, Rameshwari photocopy services, and Delhi High Court observed that fair dealing doctrine guarantees not only a public pool of ideas and information, but also a vibrant public domain in expression from which an individual can draw as well as replenish. So here the Supreme Court, Delhi High Court, they find they deal with the fair dealing doctrine, which doctrine has not uh, uh, based upon this case, that yes, they can, the Eastern Book company, they filed this case against Rameshwari photocopy services, and says that they are selling those photocopied material, study material, the books in a very convenient price to the students. So they filed a case that no, they cannot do that. But the High Court ruled that, High Court observed that, though that's no, that is they can do that, because this is for the academic purpose, right? This is for educational purpose. They can do that. So this was the case. Now next question comes into our mind many a times: are judges pass judgments? Now, judges pass judgments, and we have seen that there are certain uh, authorities, organizations, that is Supreme Court cases. Supreme Court cases. And Supreme Court cases, they what they used to do, they after the judgment, they report those judgments. They write those judgments, right, in a different format, in a different format. So the question arose before the Supreme Court, Honorable Supreme Court, that whether the Lucknow bench of Allahabad Court was correct. That means restraining the organization. The organization was read as Weir India Private Limited from reproducing judgments reported in Supreme Court cases published by Eastern Book Company. So the issue was whether uh, whether they can the Eastern this Eastern Book Company, whatever they publish in the form of reported Supreme Court cases, their issue was that those cannot be published by some other bodies. Now, the Supreme Court ruling, this ruling from the Apex Court, they permit new players in the legal publishing field to print Supreme Court judgments in book format and challenge the monopoly of a new firm. So Supreme Court denied that no, this is whatever the Eastern Book Publishing is doing. They are not doing their original work. They, in the form of like excerpts, like only the portion of the judgment they are. So in this publishing, they are not doing their original work. They are not doing any creative work, right? They are only doing their derivative work. So the Supreme Court allowed all other players that yes, Supreme Court judgments, all other bodies, they can publish and sell, and they can do their act as players in this market. Another important legal writing is in cases, in Supreme Court cases and in law reports, we have head notes. We have head notes. So the question is head notes of law reports, whether those can be copyrighted or not. So head notes, these are these things, these head notes are clear and concise language, the principle of law to be deduced from the decision to which it is prefixed, or the facts and circumstances which bring the case in hand within some principle or rule of law or practice. So the head notes of law reports are therefore original literary work which are entitled to copyright protection. Commentaries, similarly, copyright subsists in commentaries on acts also. So the author of a commentary has to bestow considerable amount of skill, labor, knowledge, and judgment in selecting materials from a large number of judgments spread out in many volumes, arranging and editing them for the purpose of stating the principles of law and practice as enunciated in the judgments, and for interpreting the various sections of the Act. So yes, copyright and commentaries can also be. Now coming to how to register copyright. Yes, we have a office for the registration. Nowadays, online registration can also be filed. And for this, for different work, they charge fee. And this fee starting from 500 for work. And in the act itself, in the annexure itself, one can see that what is the fee structure. You can easily go to the website and check what is the fee structure and what is the procedure for registration. Yes, that filing of application along with fee. First of all, one has to file the application, and the format of application is itself there. Then they will after filing, they will issue a number, and that is called a diary number. And earlier, that the mandatory waiting period for objections was 30 days, that a person has to wait for 30 days, that is mandatory. But after this amendment of the rules in the year 2021, this mandatory waiting period, now it's 180 days. So mandatory waiting period is 180 days. Now after this, if any person has objection after the scrutinization by the examiner, they can file any objection, right? And after, if no objection, then the office, the registrar office, if there is any objection filed, then the registrar office will call both the parties, and after hearing both the parties, he will say that whether application is accepted or not, or whether registration is approved or not. So this is in brief, brief, that what is the procedure of registration. And yes, this office of the copyright register, that section 9 of the Copyright Act, it requires the establishment of an office to be called the Copyright Office for the purpose of the Act. And the Copyright Office is to be under the immediate control of a registrar of copyrights, to be appointed by the central government, who would act under the superintendence and directions of the central government. So the Copyright Office is currently located in Bodhik Sampada Bhavan, plot number 32, Sector 14, Dwarka, New Delhi. That's all this are mentioned, the official formalities, the forms, how to file a copyright, those are available online also, because nowadays we can file copyright online. So that's all for today, copyright issues in legal writing. Thank you so much.
Thank you, Rumi. It is a wonderful lecture on the copyright issues in the legal writing. It is really the worth, and we learned a lot about the copyright issues. Now I request Dr. Siran Mukherjee to give the concluding remark.
Am I audible?
Yes, yes, madam.
Thank you, sir. First of all, let me thank Dr. Rumi Ahmed for this very interesting and engaging lecture on the copyright issues in legal writing. She has very well explained the concept of copyright. Uh, Going a little ahead, she explained to us the prerequisites for filing a copyright. She also highlighted on the various norms and laws pertaining to copyright matters. She very deftly dealt with the dimensions of copyright. It was very interesting to also know in the lecture the process of filing a copyright. That is, if in case somebody wants to file a copyright in his or her favor, then what is the process that one needs to follow? Uh, she explained to us the various copyright acts. Specifically, she highlighted the definition of the various terms which are explained in the not exactly explained, which are part of the Copyright Act 1957. Then she also gave us an insight into the various cases related to copyright. These cases, in fact, they were very interesting. These cases were related to intellectual property in India as well as abroad. Then she going ahead, she focused on the copyright rules 2021 of the Government of India. She tried to explain to us the what is copyright infringement and what is plagiarism, and also she tried to uh, throw some light on the basic differences between copyright infringement and plagiarism. Well, I would say in such a short time, she has made excellent efforts in giving us a detailed insight, a very engaging, detailed insight into the various aspects related to copyright and all the legal matters which are related to copyright issues. Thank you so much, Dr. Rumi Ahmed.
Thank you, Dr. Siran. Now I request Dr. Anjana. Dr. Anjana, please give the vote of thanks. Someone has raised the hand. I think Dr. Ashok Kumar Kulshrest would like to ask some question from Rumi Ahmed ji, I think. Please check. Is he available, Dr. Ashok Kumar Kulshrest ji? Are you here?
यस
हाँ, please.
मैं पूछना चाहता हूँ सवाल कि अगर किसी को मॉनेटरी लॉस नहीं हो रहा तो ये ब्रीच ऑफ कॉपीराइट होगा?
Madam Rumi ji, please.
थैंक यू सो मच फॉर योर क्वेश्चन यू हैव आस्क्ड. आपने पूछा है कि अगर मॉनिटरी लॉस नहीं हो रहा है तो कॉपीराइट इन्फ्रिंजमेंट क्या होगा. सी हमने देखा है कि कॉपीराइट का जो इशू है, केसेस हमारे पास इतने नहीं आते हैं, और अक्सर हम ये करते हैं कि हमने अपने लाइफ में कभी सोचा है कि हम अपने बुक का कॉपीराइट कैसे करेंगे. आर्टिकल हमने कुछ लिखा है, हमने कुछ लिटरेरी वर्क प्रोड्यूस किया है. द थिंग इज इन्फ्रिंजमेंट जहाँ पे होता है, ये मैंडेटरी नहीं है कि आपको कॉपीराइट फाइल करना ही करना है, बट धक्का कब किसको लगेगा, जब हमें फाइनेंशियली हमें नुकसान होता है, जब हम मॉनिटरी हमारा लॉस होता है, तभी हमारे आंखें खुलते हैं। तो ये होता ही अक्सर ये देखा जाता है कि जब फाइनेंशियल लॉस होता है तभी हम कोर्ट में जाते हैं, तभी हम कोर्ट में जाता है, अदरवाइज नहीं जाते हैं। तो ये मैंडेटरी नहीं है, आप कॉपीराइट आपको करना ही करना है, फाइल करना ही करना है, बट यस, क्यों करना जरूरी है? करना इसलिए जरूरी है कि आगे जाके जब आपको नुकसान हो रहा है, लॉस हो रहा है, तो आप फाइल कर सकते हो, एंड यू कैन ऑल्सो आस्क डैमेजेस, आप कॉम्पेंसेशन भी क्लेम कर सकते हो। सो इसलिए जरूरी होता है।
मैडम सेकंड क्वेश्चन, गेन नहीं हो रहा है कॉपीराइट ब्रीच करने वाले को, तब क्या होगा?
अच्छा,
हेलो।
हाँ हाँ, आप पूछ
हाँ
रहे हो कि
जी
गेन हो रहा है, मतलब गेन नहीं हो रहा है तब क्या होगा?
जी।
See, these are all the situations we hypothetically created कि अगर ऐसा हुआ तो कैसा होगा। See, laws in law we file cases on the basis of those cases only the पिछले वाला केस डिसाइड होता है। अब उस मामले को कोर्ट कैसे देखेंगे? अगर नहीं हुआ, फाइनेंशियल लॉस अगर नहीं हो रहा है और फाइनेंशियल गेन भी नहीं हो रहा है, मे बी कुछ रेपुटेशन का लॉस हो रहा है, मे बी उन सारे चीजों के लिए हम जैसे बोलते हैं कि कोई भी करेक्शन होता है, जैसे कि हमने देखा है कि कॉपीराइट एक्ट में हमारे पास दो रेमेडीज अवेलेबल है, एक तो है सिविल रेमेडी, दूसरा है क्रिमिनल रेमेडी, राइट? मैंने प्लेजरिज्म का भी इशू डिस्कस करा था। तो सी, फॉर ऑल दोस मैटर्स प्लेजरिज्म इशू, जैसे कि लॉ ऐसे एक चीज है, लॉ चीजों को मतलब और ज्यादा खराब करने के लिए नहीं है, चीजों को सुधारने के लिए है। तो व्हाट आई फील दैट for all those things, those plagiarism guidelines and those will be applicable, but the copyright thing, civil and criminal remedies, अगर कोई कर रहा है, ऐसा भी कर रहे हैं कि ठीक है मेरा पास कोई फाइनेंशियल गेन नहीं हो रहा है, लॉस नहीं हो रहा है, that can be stopped, इंजंक्शन कैन बी इशूड। और अगर बहुत ही लॉस हो रहा है, देन क्रिमिनल रेमेडीज कैन बी फाइल्ड, एंड फॉर दिस वहां पे हमारे एक्ट में मेंशन किया गया है अंडर सेक्शन 13 कि क्रिमिनल रेमेडी में हमें क्या हो सकता है कि 6 मंथ to 3 years तक इम्प्रिजनमेंट हो सकता है और फाइन भी लग सकता है, which is list fine is 50,000 and which can be extended up to 2 lakh of rupees.
थैंक यू।
Thank you so much, Dr. Kulshrestha.
Thank you, Dr. Kulsesh and Dr. Rumiji. If it is a crime, whether there is a financial or not, it is a crime. कुलशेष जी, जो भी है, यदि फाइनेंशियल लॉस है या नहीं है, बट क्राइम तो है ही है, तो इसको अवॉइड ही करना चाहिए, एंड इट शुड बी अवॉइडेड। कॉपीराइट इशू ऑफ द लीगल राइटिंग के लिए जो बताया मैडम ने, करना ही चाहिए। नाउ आई रिक्वेस्ट, और कोई एनीबडी वुड लाइक टू आस्क एनी क्वेश्चन? हाँ, वन मोर पर्सन रेज द हैंड, प्लीज आस्क।
मैम, आई हैव अ क्वेश्चन। सो आपने बोला कोर्ट जजमेंट्स के को जिस समय कॉपीराइट इश्यूज उसमें आते हैं, तो क्या ये सिर्फ सुप्रीम कोर्ट तक लिमिटेड है या फिर इट गोज ऑन टू ऑल कोर्ट्स? मतलब किसी भी कोर्ट की जजमेंट को हम उसको यूज कर सकते हैं या फिर उसको पब्लिकली उसको डिस्ट्रीब्यूट कर सकते हैं, किसी तरीके से वो कर सकते हैं, या वो सिर्फ सुप्रीम कोर्ट तक का ही अभी लिमिटेड है, लोअर कोर्ट्स, हाई कोर्ट जैसे हो गए? और एक और मेरा क्वेश्चन था। Yes, ma'am, please.
Regarding this question, let me answer this question first. See, the case came in the year 2016, I guess, जो मैंने डिस्कस करा था ईस्टर्न बुक कंपनी का केस। हमने देखा है कि सुप्रीम कोर्ट केसेस वो लोग करते हैं, छापते हैं, रिपोर्ट करते हैं। नाउ हियर इट इज नॉट मेंशन कि ये सुप्रीम कोर्ट केसेस का ही होगा, बट वी हैव सीन दैट इन एनी अदर कोर्ट्स देयर आर बॉडीज, राइट? गुवाहाटी लॉ रिपोर्ट हो गया, दिल्ली लॉ रिपोर्ट हो गया, देयर आर अदर एजेंसीज। तो सुप्रीम कोर्ट ने बोला है कि नहीं, सब लोग कर सकते हैं, क्योंकि ये बोला है कि सुप्रीम कोर्ट का जो जजमेंट आता है, तो वहाँ पे मतलब जो ऑन द बेसिस ऑफ दोज जजमेंट्स वो लोग जो लिखते हैं, रिपोर्ट जो करते हैं, उस कोई ऐसा क्रिएटिविटी नहीं है।
राइट।
अगर वो लोग कर सकते हैं, इफ दैट सुप्रीम कोर्ट केसेस कर सकते हैं, तो बाकी वालों भी कर सकते हैं. सो आपने जो पूछा है कि क्या दैट इज ओनली लिमिटेड टू सुप्रीम कोर्ट, दैट कैन नॉट ओनली बी लिमिटेड टू सुप्रीम कोर्ट.
ओके, तो नेक्स्ट क्वेश्चन ये था कि ये एक डिजिटल फॉर्म वर्सेस बुक फॉर्म, क्या इसमें कोई डिफरेंस होता है? मतलब
Pardon,
क्या
can you repeat?
तो एक है कि बुक फॉर्म में वो उसको रीडिस्ट्रीब्यूट कर रहा है कोई पब्लिशर, या फिर कोई इसको डिजिटल फॉर्म में ऑन इंटरनेट कोई उसको रीपब्लिश कर रहा है, तो क्या उन दोनों में कोई डिफरेंस है या फिर वो भी सेम है? फॉर एग्जाम्पल इन द फॉर्म ऑफ अ सर्च इंजन, आज के समय हम लोग देखते हैं कि सर्च इंजन हैं जो कि जजमेंट्स को ऑनलाइन अपनी वेबसाइट पे प्रोवाइड करते हैं. सो क्या वो भी इसी प्रेसिडेंस के बेसिस पे इट इज अंडर द सेम प्रेसिडेंस?
Yes.
बुक ओके
Yes.
ओके,
होगा,
थैंक यू मैम.
ये भी होगा. एंड मैंने इसलिए बोला है ना, द अमेंडमेंट केम इन द ईयर 2012, जो कॉपीराइट एक्ट का अमेंडमेंट हुआ है, दैट इज बिकॉज ऑफ दैट ओनली. बिकॉज बिफोर दैट हमारे पास इतना हम टेक्नोलॉजिकली डेवलप नहीं थे, हमने उस एंगल से सोचा नहीं था चीजों को. तो आफ्टर दैट and with this copyright act, the information technology act also goes hand by hand.
Thank you so much.
Thank you so much.
Thank you. Dr. Arun Kumar Maurya, the coordinator of Modi Nagar Study Center. He would like to ask a question from you.
थैंक यू सर. पहले तो नमस्कार आपको, अमित सर को. नमस्ते मैम. माय क्वेश्चन इज, टुडे देयर इज अ डिबेट ऑन चैट जीपीटी इश्यूज. Who will hold the copyright issue if some article is written by chat GPT? What is the status currently we have in Indian scenario?
Can you elaborate your question a little bit?
I said there is a technology based solution, that is chat GPT. If you want to write an answer, you can just speak or give a question, they are giving you answer. So in that case, if suppose any plagiarism issue arises, what is the current legal thing with that technology?
Sorry, I'm not. I have lack of expert in this question. Maybe मुझे थोड़ा सा देखना पड़ेगा आप किस बारे में. I'm not getting your question properly. मुझे थोड़ा सा देखना पड़ेगा. So sorry for that.
नहीं कोई नहीं मैम.
So sorry for that.
नहीं डॉक्टर अरुण कुमार जी, हम लोग फिर बात कर लेंगे, इसके लिए डिस्कस कर लेंगे. हमारे साथ हैं रूमी जी हमेशा, और यदि आप बताएंगे, मुझे ईमेल करेंगे rcnoida@ignou.ac.in and we'll convey to Rumi ji for the answer. Thank you very much, Dr. Rumi ji. It is a wonderful session and it is very interactive session. Now I request Dr. Anjana ji to produce the vote of thanks.
A very good afternoon to all of you. On behalf of IGNOU Regional Centre Noida, I take this opportunity to express our sincere gratitude to our resource person, Dr. Rumi Ahmed. Ma'am, thank you very much for sparing your valuable time and joining this session, being the resource person, and then delivering a very informative lecture, giving very interesting examples to us. And it was a really very interesting session, interesting lecture. Thank you very much, ma'am.
Thank you.
IGNOU Regional Centre is Noida is also grateful to Dr. O.P. Sharma, Director, NCID. Thank you, sir, for joining the session and giving your opening remarks for the session. We are also thankful to our colleagues and senior colleagues from different regional centers who joined this program, this session you have joined. Thank you very much. We had the coordinators from different study centers under Regional Centre Noida. We are thankful to all our coordinators, program in charges, and we are also grateful to the participants who asked very relevant questions and made this session interactive. Thank you very much. I am personally thankful to all my colleagues from Regional Centre Noida, all the staff members. I'm especially thankful to my senior colleague, Dr. Sinan Mukherjee, ma'am. Thank you very much for facilitating the coordination with our resource person and identifying a very knowledgeable resource person for this session. Thank you very much, ma'am. And last but not the least, I'm personally thankful to our Senior Regional Director, Dr. Amit Chaturvedi, sir. So thank you very much for your guidance, leadership, and making this program happen, for all your guidance for organizing this program. I'm personally thankful to you. Once again, thanks to one and all present in this session. Thank you very much.
Thank you. कैसे करें काम